The recording date is May 23rd, 2007. The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15, Sunday afternoon at 1 o'clock, and Wednesday evening at 9:30, here in Des Moines, Iowa. You can email us at vocaliowa@mchsi.com, or we appreciate and take phone calls from parents that are having problems with the Department of Human Services on different issues, including losing their children to the system. My number here in Des Moines is 515-276-3956. John's number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and CPI. Welcome to this report. That CPI stands for Child Protection in Iowa. And we look into a number of things, such as issues attempting to influence the issues that form around child protection, the child protection industry. They've done quite a bit along that line in the General Assembly, particularly in snatching money from the Treasury of Iowa. That's one of the favorite things, is to corner some unsuspecting assemblymen and see if you can't get them on your side, and they can help you dip into the Treasury. You're going to hear some reports along that line in a recording that we made at the Governor's Advisory Council. This is members that are, this council is formed by members appointed by the governor to serve on issues that have to do with child protection, passing out child protection money. And the money has been passed out tremendously. One of the programs that they've been using the money for is called the Happy Bear program. We'll have Don give you an idea of what that Happy Bear program is all about. Don?
Okay, John. You want to put up a picture of the Happy Bear?
Sure. We'll take a look at see if we can look at Happy Bear here. It takes a second here to.
Can you freeze that?
No.
Isn't he cute?
Yeah. By the way, that suit, if you want to be a Happy Bear, that suit's going to cost you $795. And notice it doesn't even have any pockets in it, and the $795 doesn't include a vest and a tie. You'd think that if you wanted to be a good Happy Bear, you'd have at least a vest and a tie, wouldn't you, Don?
What type of people would be interested in buying that?
Well, it's people that are in some kind of a project that is sponsored by state government, and the money is passed out to them in grants. to teach children in elementary school about the problems of sexual abuse.
So the money is given to them then to buy that suit then.
The money is extracted forcibly from taxpayers of Iowa. They don't have any choice about whether they want to contribute to it or not. They're forcibly assessed that money through taxes, and the money is handed out by the millions, and grants are written all over the state to have silly little programs like Happy Bear program. Well, the Happy Bear program has been in practice for a number of years, and has been well received, but they're finding out that it's not all that great. So what it means is that we've been spending taxpayers' money inefficiently, not doing the job for which the money was extracted in the first place. Don, tell us a little bit about that.
For over 10 years, Family Service and Guidance Center has been taking its cuddly costume character Happy Bear into classrooms, school assemblies, and a variety of other settings to teach children about a subject that is not easy to talk about: sexual abuse. With the help of his quote teacher unquote, a highly trained FSGC professional, that stands for Family Service and Guidance Center. And do we have one of those in Des Moines, John?
I don't know.
Okay. And the eager children attending the program, Happy Bear learns about good touch, such as a pleasant hug, bad touch, which means hitting, it says here, and mixed up touch. Sexual abuse, that means. Mixed up touch is sexual abuse. For little kids, doesn't that get kind of confusing, what all these terms mean?
Yeah, that's when the child is supposed to report if it's confusing to them.
Oh, and who do they report? Their own parents.
Oh, a school counselor is a good one to report to.
Well, yeah, but they talk about their or what they see at home.
Yeah.
All presented in a way that is age appropriate and easily understood. Well, that's a question there. They're in a training field there. They're training the children. Okay, the article goes on. Designed for youngsters aged 5 to 8, this highly interactive and fun program not only brings about awareness among children and others who attend, but it teaches perhaps the most important message of all: protection of oneself and prevention of sexual abuse. Well, on the surface, John, that sounds like a good idea. Well, it goes on. Children learn what to do if they experience bad or mixed up touch. The presenter never names body parts, but refers to body parts they cover up with their bathing suits. Via the school or organization, parents receive a letter from the Guidance Center in advance of the Happy Bear presentation, allowing parents to call the Guidance Center and ask questions or discuss concerns they may have. Parents always have the option of not having their child attend. They're referring to school for one thing.
Right.
I doubt if that's always the option for parents. I doubt if they always know what's going on in school. Finally, oh yeah, there's probably a note comes home with the kids, but if it only gets out the door and then blown away in the wind, the parents would never hear about it. The article goes on. Finally, parents are highly encouraged to attend so they can better understand Happy Bear's important message and talk openly and honestly with their child. John?
Well, this year seems to me that they've had quite an emphasis on sexual abuse, which is a misguided uh, activity, in my opinion, because first of all, and this is not to protect child abusers. First of all, I saw an article just the other day, and I should have brought it to the studio. Said sexual abuse reports drop 37%. Well, if we're down to like a 4.7% level, we're down to single digits in sexual abuse. Uh, does that mean that we should go to the legislature and get more and more and more money so we can tell more and more parents about sexual abuse, which is dropping year by year? I think the whole idea is the fact that sexual abuse is a hot button word, so that if we can use that, we can use that concept in our fundraising campaigns. And fundraising is done at the legislature. I think for one of these funds, they were asking $650,000, and they were sad because they only got $200,000. But they were still grinning, because this is still money they didn't have before. But the legislature was just passing out money like there was more to be had after they spent hundreds of thousands of dollars on these programs. The programs seldom ever show or even attempt to show that they have a purpose and that they can fulfill a specific purpose. The programs on sexual abuse are very poor at showing that. Secondly, the target audience is the wrong audience. The people in our state who should be doing the most for guarding against sexual abuse are the caretakers of the children. Why would you bring a 4-year-old into a class with a happy bear to talk about a subject of this sort? Don't even name body parts, but you talk about all of these things that make them feel uncomfortable, and then you present it in a fantasy form. Children are akin to fantasy. They are not akin to serious subjects. Their parents should be. And it's the parents that ought to be doing the protecting and watching out for the children. It shouldn't be the children who must distinguish between good touch, bad touch, confusing touch, and sexual abuse, and so on and so forth. That's a pretty heavy concept to lay on a 3-year-old or a 5-year-old. Those young people need the guidance and protection from a caring adult like mommy and daddy. But it seems as though they want to focus attention and go to the children. Well, they're finally getting around after years of gathering money from the legislature and putting out these programs like Happy Bear. They're finally getting around to the point where they're saying our most productive efforts should be with parents. Then when we start looking at the numbers that are involved, it's kind of silly, is it not? When the percentage of abuse with respect to sexual abuse is declining every year, then why should we be putting greater and greater emphasis on it? Well, of course, I guess I touched on that. It is a good hot button word that helps fundraising. And fundraising is very important out in these communities where they want to spend taxpayer money hiring staff and setting up programs that are virtually worthless. Perhaps they'll get around one of these days to recognizing that these programs are worthless. Well, and
Not
now
only are they worthless, but they are influencing our children in an improper way.
I think you're right. They are in that fashion. Then they are counterproductive. And I've even heard kids being assigned, like in 6th grade, writing themes about sexual abuse. Well, why in the world in a situation where they need to be learning language arts, they need to be learning geography, they need to learn how to talk properly, they need to know how to write reports, but we're telling them that they've got to write reports about sexual abuse. That is really silly. And so these kids are launched into all kinds of fantasy thinking because Happy Bear came to visit them. I think it is horrendous that we have to support programs like these that are not only senseless, but in many cases, like Don says, are counterproductive. There are a lot of fearsome things that are going on in the child protection area. One thing, and we've mentioned this case of Wei-Ling Ching, who recently lost her daughter to the system. The unique situation about Wei-Ling Ching is that her daughter was removed from her care without competent evidence and without the exercise of rule of law. Whenever there is a situation where competent evidence has left and there is no rule of law, that situation is called tyranny. We have a good mother whose child was removed because the judge had a different way of thinking. And that thinking was not guided by rule of law. Her case is before the Iowa Supreme Court, and it will be rather interesting to see, well, first of all, to see how the Department of Human Services responds to the petitions that have been filed. They don't call them briefs anymore. They call them petitions because they can't waste the time that it takes to put together a real brief, because all this is just one or two children, and so they operate on something called petitions to resist termination of parental rights. But that petition will require that the Department of Human Services respond to some very important questions, deficiencies in the system in which the Department of Human Services was an active character in helping a tyrannical system remove a sweet little girl from a good mother. Shouldn't happen, but in our society it does happen. Have the courts really gone silly? Well, we've consulted with a fellow who looks into these court matters and advises us from time to time and brings articles not only from Iowa but from other states demonstrating just how corrupt a system we really have. Let's turn to a fellow who would like to see courts reformed, Terrance Walker.
Thanks a lot, John. Once again, yes, I'm the judge of the judges, and this is why I'm hot. So, just wanted to thank you. You always give me a good introduction there, and I think that we do need to really focus on some reform efforts here in the United States, and more closely here in Iowa, so that we can not have situations like Wei-Ling's, in which the child was removed basically because the DHS wanted to pursue their course of action instead of letting her pursue her course of action and maintaining her experts as to what had or had not transpired. But I don't think I can talk about too much of that case, but I guess you guys are free to look that up on the internet at the I think you might have to do a search for the initials, however.
The initials will be TD,
It'll be TD.
in Ray TD.
And I think the party would be reference WLC or something like
Bring your
that.
mic up a
Okay.
little. Okay.
Yeah. I don't want to be heard here.
Okay, right.
All right. Now, there's a couple cases that pertain to judicial reform, and I think there's some interesting cases that I think that are across the nation here. One I wanted to shed some light on because I think that it's important. This is an important decision. One time, the court actually made a favorable decision in favor of the average Joe, individuals like you and I. There's been occasions where I, and I'm sure you and some people that you've known, John and Don, that have tried to go to court and basically represent their children or represent their children's interests. And one of the things that the court has said in recent years is that parents do have a fundamental liberty, interests, and rights as it pertains to their children's educational needs, their clothing needs, whatever are essential needs for their children. And the thing that really used to irk me, you go to court and you're representing your child's best interest on a matter, and the judge would always say, well, you can't represent your children. They need a guardian ad litem. They need a special representative for them. And, it's kind of dumbfounded me because, who would best represent their child's best interests other than their parent? And if they're capable of pursuing the legal matter themselves, then why not? Why shouldn't they be able to? Well, the High Court has basically, in a case involving Sandy Winkleman, and I think you got a picture of that, the individual. Sandy Winkleman, this Monday, the Supreme Court of the United States, this is reported out of the Washington Post, Tuesday, May 22nd. But on Monday, the Supreme Court ruled that the parents of disabled children do not have to hire lawyers to sue school districts when they attempt to ensure that their children's special needs are adequately met. Now, this lady, Sandra Winkleman, and her husband, who's pictured also in the back, basically sued to basically get, on behalf of their son, who's, I think, was autistic. And the court found that the Federal Individuals with Disabilities Education Act, IDEA, which guarantees children a free, appropriate public education, gives rights to parents as well. Parents may represent themselves in a federal court when disputes arise between them and a school district over what is best for the child, the court held. The decision would allow more parents unhappy with education plans drawn up by their children, for their children by school districts to sue for changes. And some parents of disabled children contend that it is expensive and often difficult to find lawyers who take such cases. Well, yeah, a lot of these guys want 5 or 10 grand up front, And, I can't blame them. They got to make a living too. But at the same time, how is the average person going to shell that out? There's a lot of people that are in financial turmoil right now. This is a bad economic time now. Who has 10 grand sitting around to just give a lawyer? And, and worst case, and even worse, when the lawyer says, well, I don't know what the chances are. So,
And even worse is you lose in the end.
and even if they did say that they had good chances, like Don says, you still lose. So there's 10 grand down the drain. So federal courts generally allow individuals to represent themselves, but not others without the aid of a lawyer. The U.S. Court of Appeals for the Sixth Circuit, which there's 13 different circuits here in the United States, they dismissed the Winkleman's appeal on behalf of their son Jacob, unless they obtained counsel to represent their son. And the majority said a comprehensive reading of the Act, IDEA Act, makes it clear that parents have rights at each stage of the process and thus may represent themselves in federal courts. Now, the idiocracy of the Court of Appeals and whomever made the initial ruling said that they couldn't represent themselves. The idiocracy of the process here, they basically were allowed to represent their child throughout the whole administrative proceeding. But yet, all of a sudden, when they got to court, oh, you can't represent your son anymore. So I don't understand what the problem was. But this is one case I would say the United States Supreme Court did clear the way for the average Joe and the average man. Now, we do have unaverage people here in the state of Iowa, and I'm going to bring it back home. We've been talking about issues that affect the whole national scheme of things. The past several episodes where I've been on the show talking about the judiciary, I think it's time we got to bring it back home because we've got a very interesting individual here in the state who happens to be a judge, Judge Weaver, out of Muscatine, I believe, who basically he's had his run-ins with the law and with alcohol and drugs, or you name it, the past several years. And I've actually brought him, we brought a story out pertaining to him about a year ago, and I think a year before that. Well, this Muscatine judge, I think you got a picture of him. Don, you put him on the, or we can kind of detail some of his things that he's got going on. Well, make a long story short, you want to put a picture of him. This is Judge Weaver from Muscatine, former judge, I should say. He was basically removed from the bench. And this guy has, you want to go down the list of things that he's done here the past 5 or 6 years. Now, this all started with the judge back in 2002, November. He was arrested for drunk driving. He was sentenced to 4 days of home detention in order to pay $1,100 in fines. Chump change for a judge, of course. September 04, officials complained of erratic, rude, and emotional behavior by Weaver. Some allege he appeared at the courthouse smelling of liquor, and then he was placed on medical leave with full pay. November, he was arrested and charged with second drunken driving. Within days, he files a formal request for a disability retirement, saying he's permanently incapacitated. And then December 04, Iowa Supreme Court Judge Louis Laverado grants Weaver a disability retirement, and they start paying him $4,900 a month in retirement benefits. And then January 05, with his law license in good standing, he contracts with the State Public Defender's Office to represent indigents as court-appointed defense lawyer. And then April of 05, he pleads guilty to a second drunk driving charge and is sentenced to the Iowa Department of Corrections treatment program. He appeals and tells a newspaper reporter that the sentencing judge isn't being honest. Well, isn't that the pot calling the kettle black? But anyway, the interesting thing about this whole case is that we've got a judge that's getting disability benefits for being permanently disabled, and then at the same time, he is getting money to represent he's basically getting money to represent indigents, poor people. So in a sense, we've got a judge a guy that's not fit to be a judge, but, I guess he's fit to be a lawyer, which for the poor, I mean, I don't know if that's good or bad. I mean, I would rather, if I got a choice, I'd rather have somebody that could be effective in both capacities, since the lawyer has to basically influence a judge in your favor. So why would you have somebody that's not capable of influencing or having the capabilities of understanding the law and being effective with the law as a judge, but yet, you get a substandard person that drinks. But anyway, in April '07, let's go back to the chronicles of Judge Weaver here. And he's reprimanded in basically in '07, April '07, responding to his 2004 arrest and Weaver's characterization of the sentencing judge. The Grievance Commission of the Iowa Supreme Court recommends that Weaver's law license be suspended for 3 months. Now, this is after he criticized the sentencing judge for basically sentencing him for his second drunk driving offense, which, most people spend an arm and a leg and a lot of time in jail for even having 2 or 3 OWIs. But the judge here, James Weaver, he's basically what he's saying is he's really retired in this article by Clark Kaufman here from the Des Moines Register, and he says, I'm not on disability, I'm retired, and since 2005 he's got about $139,000 from the state in benefits as a result of his disability retirement. At that time, he also collected $7,500 in fees from the state as acting as court-appointed attorneys for 31 indigent defendants, or poor people, basically. Now, when he filed and swore on his affidavit for his disability, he cited the devastating effects of his depression and alcoholism, and he wrote that he believes that the combination of the disabilities caused by these diseases is permanent, incapacitates me both physically and mentally from performing the duties of a district associate judge, and clearly interferes substantially with the performance of my judicial duties. Now, he subsequently works as a criminal defense lawyer. And when questioned about this, State Court Administrator David Boyd, whom we've had the occasion to interview on the show a couple years back, said that while some people might be incapable of serving as a judge, they could be well qualified to serve as a criminal defense attorney. So, in essence, people, if you got a guy that drinks so bad that he has 2 OWIs, he's good enough to be your lawyer. That's what they're saying. But he's not good enough to be a judge. It's a different responsibility, David Boyd says. Now, someone might say, well, gee, being a judge is the same as being a lawyer. And frankly, that's not the case. The issue of disability retirement is a separate decision and process from the question of whether someone is qualified to be a lawyer. I would beg to differ, since the professions are so inextricably related, and how the qualifications for one are not necessarily that different from the other. Did you have a
Maybe that
comment?
opens it up to a complaint then against the attorney. There was a complaint, I think, against the judge. Now there needs to be a complaint against the attorney.
Yeah, well, the thing is that the whole this whole thing has really been spiraling out of control on another tangent, because it seems, even though he was supposed to be suspended for 3 months, the court had not yet acted on that recommendation, and when they basically allowed him to serve as a lawyer, they never did suspend him. They never did act on it. So what happened was he was a lawyer for a certain amount of time. He basically, what happened after that is that they had severed his contract with the state, and due to the Des Moines Register inquiring about it, they found that at the court office there that there was no contract between him and the state. And then on top of that, he asked to have an expanded area which covered 8 different counties surrounding his eastern Iowa county where he was representing clients. Well, they expanded his area, but yet he didn't even have an existing contract with the state to operate at the time. So, here we have a judge for one, 2 OWIs, and he's permanently disabled. So he says, in his own words, he's permanently incapacitated to serve as a judge because of his alcoholism and his mental depression. But, and then he's allowed to be an attorney, but he doesn't even have an existing contract. And then they approve his contract, supposed contract, to operate in other counties. So, I mean, this thing just spirals out of control. But, it just goes to show you that there's 2 different standards. There's their standard, and then there's our standard. Their standard says they can do what they want. Our standard, we can't do anything. So if you or I were to walk down the street or drive down the street drunk once or twice, we could probably be rest assured that we won't get retirement benefits, or we won't get fired or suspended with full pay, for one. For two, we won't get disability benefits for being fired.
That's right.
So, and then on top of that, we won't be collecting even more money from the same entity that we were supposed to be retired from for being disabled for mental depression and drunkenness. We won't be getting then paid by that same entity for more work.
Right.
So it's 2 different set of rules in the game here, and that's why we call it the Iowa Just Us system, because it's
Right.
it's definitely not for us.
One for the princes and one for the peasants.
There you go. That's
bet.
my commentary for today.
Thank you, Terrance, for that review. We're going to going to peek into a few minutes into the room where the Governor's Commission, or Governor's Committee on Child Abuse Prevention Programs is being held. In this program, you'll meet Governor's sidekick, who's been appointed to look into these things. He wants to set up an entire another layer of government oversight of the DHS. And DHS recently said, no, they don't need any more oversight. They in this program, you'll hear him talking about universal home visits. That was one of the things that was discussed in the recent General Assembly. They want what they call the super nanny to come in and tell you how to raise your kids. First mention I've ever heard in a discussion about maybe considering dads. Maybe this dads movement has caught on. One thing they talked about is sexual abuse. Apparently, they're beginning to understand that stranger danger is not the real problem, because most children are abused by people they already know. So the stranger danger is a silly thing. They spoke a little bit about the 2,000-foot rule, and well, that's about all of the notes I have for the time that we have going here. So we're move right now to that annual meeting of the well, it's an annual meeting of an organization that spends all this money for the state. They have to have help in order to spend money. So they contract help with an organization called PCA, Prevent Child Abuse Iowa. And they have a tremendous budget, most of which comes from the good hearts of the taxpayers for the state of Iowa. Isn't that marvelous? Well, let's see if we can find their program here. It should be coming up here in just a moment. Come on. Are you there? Let's see if that cameraman has has,
And
here it comes.
Anybody's welcome to sit at the table if you'd like. It's not reserved for anybody in particular. The purpose of the meeting is, it's multiple. One is to report on 2007 legislative activities, particularly the expanded ICAP funding for sexual abuse prevention programs, and to receive a report from a presentation from Peggy Jones, who's delighted to have you with us for our meeting, and to receive questions from you about the grant program and to discuss anything that you all have on your minds to get input to the Governor's Advisory Council.
This was a special speaker that was flown in for the convention of some 500 social workers and therapists.
Floyd Winter. I'm on the Governor's Advisory Council, and I also do community coordination work with Cedar Valley's Promise and our Empowerment Board locally in Blackhawk County. And I also chair the Iowa State Empowerment Board.
And you basically work harder in retirement than you did.
Yes.
Yeah, I don't have as many things to report as Floyd does. I'm Christy Thies. I'm with Prevent Child Abuse Iowa.
John Harvey, local Iowa.
I'm Priscilla Wanaki from the Governor's Advisory Council, and I'm from the settlement.
Steve Scott with Prevent Child Abuse Iowa.
I'm John Hedgecock. I do Health and Human Services Policy for Governor Council.
Lisa Porter, SKCAP, Child Care Resource Referral, and Crisis Child Care.
Lori Peterson, I just finished an internship with Family and Children's Council in Waterloo.
My name is Lynn Beich. I work for the Area Education Association / Early Access in Sioux County.
Judy Songer with Cedar Community Action Agency in Ottumwa. Luann Lowry, Family Resource Center. We have, we're at 26th year. I think I've been here 25 of them. So okay. And we were one of the first Prevent Child Abuse Councils in the state.
I'm Ann McQuarrie, and I'm with the Hawkeye Area Community Action Program. I am the manager of the Crisis Child Care and Respite Care in Lynn County. And I don't think I've been here as long as you, but probably 22, 23 years.
I'm Valerie Owens. I'm with Healthy Connections. I'm a home and community-based Medicaid waiver agency.
I'm Judy Taylor. I do a sexual abuse prevention program in Clay County called Happy Bear.
I'm Mary O'Dell from Lutheran Services in Iowa, and I oversee all of the early childhood programs for Lutheran Services.
I'm Peggy North Jones, and I'm an independent consultant, but also with Parents as Teachers National Center in St. Louis.
And I'm Brenda Risfet with the Buchanan County Volunteer Co-op. We do healthy families, crisis, respite, parenting, education.
I'm Nancy Curry. I'm with Parent Share and Support at Fayette County. We do primarily parents as teachers. We do crisis care, emergency child care. Yes, I'm here.
Yeah. Julie Pitson, I'm the Director of Family and Children's Council in Blackhawk County. We are the Child Abuse Prevention Agency there.
I'm Colleen Reisner. I'm the coordinator for the Warren County Child Abuse Prevention Council. We have a respite nursery, a young parents program, and a new sexual abuse prevention initiative.
You'll be hearing a legislative briefing very shortly here in this presentation.
Marshall, Hardin, and Tinker counties.
All of the good things that happened to DHS and others in the recent General Assembly.
I'm Nancy Bean Blossom with Lutheran Services in Iowa, and I have the Hope's Healthy Families program in Blackhawk County, and I have our early intervention program called Families Together in Floyd Mitchell Chick and Bremer Butler Franklin Grundy, and we do parent education, Young Families Initiative, and sexual abuse prevention.
I'm Judy Judd. I'm with the Young Parents Network in Cedar Rapids. We do a parenting group that just did a sexual abuse awareness training. We also do Parents as Teachers as our home visit program.
I'm Nancy Pallardy. I also work with the Young Parents Network, but I'm in Iowa County and do Parents as Teachers and a small portion of the empowerment hours.
I'm Sheila Graham, and I do youth ministry at the Catholic Church in Council Bluffs, and I also, for the Diocese of Des Moines, I teach it's called Burgmaier, Protecting God's Children. It's a prevention of child sexual abuse program.
I'm Cheney Yates, and I'm with the Child Protection Center here in Des Moines at Blank Children's Hospital.
I'm Paula Milo Ward, and I work for Clark County Public Health, and I did parents as teachers on visits.
And we had one more person join us.
Nola Elbers, Northwest Iowa Council for Families and Children, Empowerment and Detail.
Thank you. Well, I'm sorry.
I don't know if you're asking just what our PCA Iowa program or what we do. Just PCA.
Whatever you'd like us to do.
Okay, well, I'm the director of the People Place, which is a Lutheran social service, Lutheran Services in Iowa program. And we have all kinds of parenting classes, workshops, support groups, parents as teachers, this is the names.
Your names. Okay. Great. Well, welcome everybody. We're glad that you came. Can I have the council members, if you've reviewed the minutes of the February 21st teleconference meeting?
I would move for their approval.
Thank you.
Second.
Okay, all those in favor?
Aye.
None opposed? Yes? Okay, Steve, are you going to give us the report on
I
the
sure will.
2007 legislative activity?
I actually want to end with the more positive news, as opposed to starting with the best and going to the most disappointing. But anyway, we came, the first one success to highlight right away is that for now the 5th year in the row, the Iowa legislature has expanded funding for the community partnerships. Started with $169,000, has basically come up with at least $100,000 each year thereafter, and they added another $100,000 this year. What they've basically done is tried to keep a little bit ahead of the train as the train moves along. As you may know, the partnership has been expanding throughout the state. Will now be in 97 of 99 counties, with Cedar and Ida, shocker there, being the two that are the holdouts against being part of the community partnership. So they've been adding about 15, 20 counties a year. So it's certainly very helpful to continue to grow this. There's now about $1.2 billion in federal and state funding coming into it. There were a couple very, potentially very significant new programs that came close to getting enacted but did not. One of them was a program to reduce the likelihood of shaken baby incidents, focusing on trying to reduce shaken baby incidents, but also looking at the whole issue of parental stress and how parents respond to stress. That has been done in a number of different ways throughout the United States. It's been done with parents being essentially given the opportunity to watch a video in the hospital during their 48 hours there, to being given the video to take home, to having it shown to them in some kind of a parent group context, to having it sometimes offered in a home-based setting. As proposed in this legislature, basically this program would have been integrated into existing family support programs. Now, some of those programs already address this issue pretty well, address the issue of stress, address the issue of how you respond to the buildup of tensions and the difficult times that parenting sometimes presents. This one did get through a Human Services Committee, but did not proceed any further. It is our hope that the Department of Health will perhaps support this program, and it might even become part of their budget, or the governor's budget. It was a pretty minor price tag at the end of $100,000 because it was basically integrated with family support programs. A second program that would be much more substantial than this, at least in terms of how it would roll out eventually, was one that would have started this year with Empowerment taking on the responsibility for planning how to do a universal home visiting program, universal voluntary home visiting program. It is how would we reach, or at least try to reach, all the families with newborns to offer them the opportunity for a home visit with the hope that they would be integrated into opportunities for support if need be.
He's talking about the super nanny concept, and they've brought that up in the last couple of years. It didn't pass in this legislature, but they're thinking about pushing it again in the next.
So it did not.
So it won't be long until we'll have someone watching over our shoulders as to how we raise our little babies. I thought that was Grandma's job.
About and proposed last year did not really go anywhere last year. So this was a significant amount of progress this year. I think the more substantial of the two programs in terms of what it will ask for, since there are 36,000 children born each year, is the universal home visiting. Because again, this would be somehow working with hospitals to see that there was an outreach to parents that certainly occurs somewhat nowadays, but not on a universal basis. Any questions about those two? I know some of you I even talked to through this as to what made sense for strategy. The first one would have been Department of Public Health, the Shaken Baby, although perhaps with a contract to carry out the effort. The second would have been the Community Empowerment Office.
Steve, I had the figures in my head at one time. Approximately of those 36,000, how many are we currently reaching? Approximately.
I really don't know.
Because we have several programs.
There are about 15,000 families that receive some kind of support. Those would be up through 5 years and some even older. So that would be maybe 10% of those with newborns. Now this again would not be creating a brand new ongoing home visiting program. It would be essentially a one-time program that would probably primarily involve an assessment as opposed to any kind of services being delivered. The one option considered and not followed would be to try to create some sort of clone of a super nanny, super parenting, super health nurse kind of person who would go in and be able to tell everything that needed to be known about the child's health, psychological well-being, and basically tell 4 or 5 pointers that would ensure safe parenting forever.
First comes the stork, then comes the super nanny.
This would again be primarily to assess, see what was needed, and hopefully connect up with the hope, again, that there is something to be connected up to. Okay, why don't we mention...
Can I just
Sure.
make a comment about the Shaken Baby? I know we talked briefly on the phone about that. I was kind of excited about that possibility, but I was hoping that maybe it could be linked with parent education programs, and I was particularly thinking about our dad's program. If you look at what's come from the child death review team, looking at men taking care of infants but not receiving a lot of support for that, I have some concern about that. So I'd like to see some link with that down the road. Just a comment.
And a very good comment. There was certainly a recognition that the traditional ways that we think we reach parents don't reach everybody we should.
A video shown in the hospital may not reach out to fathers or parents that would need that information.
The other thing that this would have done is actually taken it beyond the family unit to child care providers, so perhaps sitters and others as well. Obviously, as we look at all the people responsible for caring for newborns, it grows far beyond the 36,000 parental units each year. Why don't we talk a little bit about how the legislature responded and didn't respond to the issue of child sexual abuse and its prevention. As probably most of you know, if you happened on a newspaper sometime in the last 3 or 4 months, there was a proposal from the Iowa County Attorneys Association, supported by the Iowa Sheriff's Association, our organization, Iowa CASA, 64 of the 99 county board of supervisors, that basically asked the legislature to step back and examine what really are effective ways to protect children from being sexually abused. The legislature's response so far has been focused primarily on stranger sex offenders through the residential restriction that was the particular target of the advocacy coalition that is getting rid of the 2,000-foot restriction on how close sex offenders can live to schools or to child care settings, but also look at other ways that this could actually be prevented.
You see, they're afraid of doing that. Legislators are afraid of getting rid of that 2,000-foot rule for fear that people might think that they're soft on crime. So they're willing to uphold a stupid statute that is costly and abusive and illegal, but they'll do it for political gain. And that is 100% of the membership of the Iowa General Assembly.
Resources and absorbing far more staff than is necessary. But it actually is a net minus because it drives people underground, they don't register, nobody knows where they are, or they go out into remote areas where they can't even be tracked through GPS if they're supposed to be tracked, or they live clustered together in motels in Cedar Rapids and other places like that. So they heard that as clearly as could be, and there certainly was not the political will to do anything about it. There were some efforts toward the end of the legislature that would have nibbled at it a little bit, and it just was too little too late and did not come into being. That is a significant disappointment. The likelihood that anything will be done next year has to be even more minimal than minimal, given that that's running right up against the legislative election. Maybe it could have rolled out differently. There's no question that there's, shall we say, an oppositional element to the legislature in any year, but certainly this year, where no one was going to do anything to make it easier for someone, and for the majority party, they did not want to be seen as the only ones doing something about sex offenders. Nor was there a consensus among the leaders as how best to do things. Nonetheless, out of all this, there did arise legislative support finally for addressing the issue of preventing sexual abuse in the first place by working again on issues of adult education as well as expanding child education. We have, the figure was 200,000 is what we ended up with. It will allow a significant expansion of this program. It will more than double what goes out for sexual abuse prevention. And it will really allow moving somewhat to scale, not just the child focus, which has reached almost half the Iowa counties, but also to move out something to the adult piece. Coincident with that, we have a proposal into a foundation, to Greater Des Moines Community Foundation for an evaluation of the adult-focused effort. Carol Plummer, who spoke last year at the conference, will be doing that, basically doing an assessment of what parents learned after the instruction, but also revisiting parents 3 months out to see what they will be doing. We are very excited about that, this effort. We've talked to some of you around the table who also are excited about doing that. Sue happens to have a map to her left with what the proposals have been.
That's his right.
Yeah, the gray are the counties that now have programs. The blue are ones that will be continuing their programs and are seeking new programs, most of them adult focus. And then there are 3 or 4 that did have programs, Page, Fremont, Adair, and Washington.
You're viewing a meeting of the Governor's Advisory Committee on Child Abuse Prevention Programs. This is a director of PCA who administers those programs throughout the state. For a few $1 million, he'll do things like that for us.
The proposals we received, and again, this is just from skimming them, not by any thorough reading. We received a total of 67 proposals requesting sexual abuse prevention funding. 58 of those proposing to do child instruction, 44 proposing to do adult instruction, and 6 proposing to do public awareness. So we're really excited by the breadth of proposals we received. We look forward to grant review.
Probably safe to assume that 200,000 wouldn't cover everything that we're going to be asked for.
We want to thank you for watching the CPI report. We may be able to hear more of this tape later on. For right now, we'll say see you next week.